the separations of powers. Bureaucrats don't create laws. Congress does.
The ATF before they abolish our Second Amendment rights. Alcohol, tobacco, and firearms.
Now, you could argue, actually, that the pistol brace makes the gun safer.
Which changes now we have an administration that is desperate to erode our Second Amendment rights.
The impulsive leaders at ATF have once again failed to apply simple logic and reason to their decision-making.
And now the ATF, under the guidance of this administration, is coming to take away
concealed carry crisis. The legal landscape surrounding California's concealed carry ban, specifically under SB 2, has taken a complex turn, with implications for the Second Amendment rights of millions of Californians. The recent administrative stay issued by the Ninth Circuit has allowed the full implementation of SB 2, restricting the ability of individuals with valid concealed carry permits to exercise their right to carry an arm in public. The legal challenge, known as the May versus Bonta case, centers around the constitutionality of SB 2, which imposes new concealed carry restrictions and was enacted in response to the U.S. Supreme Court's recognition of a general right to publicly carry arms for self-defense. The preliminary injunction issued by Federal District Court Judge Cormac Carney temporarily blocked certain aspects of SB 2, providing relief for arm owners. However, the state of California appealed the decision and sought an emergency stay, which was granted by motions panel of the Ninth Circuit.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
Proven fighter for the Second Amendment, Mr. Clyde, for organizing this special order. Thank you so much for
The ATF before they abolish our Second Amendment rights. Alcohol, tobacco, and firearms.
Makes it less likely for people to shoot things they are not aiming at.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
It emphasizes that the situation, if left unaddressed, is akin to suspending the right of free speech during protests for administrative reasons. From a constitutional law perspective, the motion contends that plaintiffs find themselves in a situation no different than if the state had passed a law banning protests in public spaces. It highlights the urgency of addressing the administrative stay, as the current situation infringes upon the Second Amendment right and poses a significant constitutional injury. The motion requests the motions panel to reconsider and immediately dissolve the administrative stay to restore the status quo of concealed carry rights in California before SB 2 took effect. Alternatively, it seeks an expedited transfer of the case to a merits panel and a quick resolution of the state's emergency stay motion. In essence, the motion urges the Ninth a swift and decisive legal response. Legal battle intensifies. A recent decision by a conservative three-judge panel of the U.S. Ninth Circuit Court of Appeals has intensified the legal scrutiny surrounding California's laws on openly carrying hand-arms in public. The appellate court found that a lower court abused its discretion by not halting state enforcement of these laws while their constitutionality is being challenged. While the ruling did not immediately halt enforcement, it mandated a reconsideration by the lower district court, providing explicit instructions on how the analysis should be conducted. Legal experts suggest that this decision sets a more challenging standard for the state to demonstrate the constitutionality of its laws. Jake Charles, an associate professor at Pepperdine Caruso School of Law and an expert in arms law, noted that the court's stance implies skepticism about California's ability to meet the burden of proving the law's constitutionality. This development reflects a broader legal debate around armed rights, particularly the tension between state regulations and the interpretation of the Second Amendment.
Now, you could argue, actually, that the pistol brace makes the gun safer.
and said he supports a ban on the sale of assault weapons, which there's no such thing,
and call on young people to continue leading efforts to end gun violence.
For highlighting what's going on here. Mr. Speaker, the ATF's new pistol brace rule violates
tearing apart families and making our streets less safe.
This rule functions like a law that Congress never passed.
The decision by the Ninth Circuit Court adds another layer of complexity to this ongoing legal discourse. As the case undergoes a fresh analysis at the district court level, the legal landscape surrounding open carry laws in California may experience significant shifts. The decision's potential implications extend beyond the immediate plaintiffs, potentially influencing the broader interpretation and enforcement of arm-related regulations within the state. In light of the heightened scrutiny in evolving legal dynamics, stakeholders, including lawmakers, legal experts, and advocates, will closely monitor how the case unfolds. The outcome could have broader implications for the balance between individual arm rights and state regulations, shaping the contours of arm laws in California and potentially influencing legal precedents in the broader context of arm regulations in the United States. Second Amendment legal shift. The case of Baird versus Bonta has gained prominence as a part of a wave of challenges to California's arm laws, particularly in the aftermath of a U.S. Supreme Court ruling that heightened scrutiny on arm restrictions under the Second Amendment. The Supreme Court's decision, as seen in the New York State Rifle and Pistol Association versus Bruin case, introduced a transformative legal standard known as the Bruin test. This test shifts the focus from the public good served by arm laws to an evaluation of historical roots, demanding that arm regulations be deeply rooted in the nation's history or analogous to historical rules to be deemed constitutional. The Bruin test marks a departure from traditional considerations and requires courts to assess whether modern arm regulations, especially those pertaining to arms like attack rifles, have historical precedents.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
Which changes now we have an administration that is desperate to erode our Second Amendment rights.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
The separations of powers. Bureaucrats don't create laws. Congress does.
The emphasis is on determining the historical lineage of laws rather than solely evaluating their contemporary impact or societal benefits. California's arm laws, subject to ongoing challenges, include restrictions on openly carrying hand arms for residents in countries with over 200,000 residents. However, exceptions exist, and individuals in jurisdictions with fewer than 200,000 residents, such as the plaintiffs in the Baird versus Bonta case, have the option to apply for open carry licenses. Yet, obtaining such licenses remains a challenging process. Mark Baird and Richard Gallardo initiated their legal challenge over 4 years ago, asserting that California's laws infringe upon their Second Amendment right to bear arms for self-defense. The tension between individual rights and collective safety, exemplified in California's concealed carry laws, is emblematic of the broader national debate on the scope and limits of the Second Amendment. This case, along with others challenging arm laws, becomes a microcosm reflecting the changing landscape of constitutional interpretation and the dynamic interplay between historical roots, individual rights, and contemporary societal considerations in the realm of arms regulations. The outcome of these legal battles will not only shape the trajectory of arm laws in California, but may set precedents influencing similar challenges across the United States. Strict scrutiny unveiled. The recent ruling in the case of Baird versus Bonta by Circuit Judge Lawrence Van Dyke, accompanied by Circuit Judges N. Randy Smith and Kenneth K. Lee, has significant implications for California's arm laws and reflects an evolving legal landscape shaped by the Bruin test and the broader discourse on Second Amendment rights. The case's central focus lies in the challenge to California's laws on openly carrying hand-arms, with Mark Baird and Richard Gallardo contending that these laws violate their Second Amendment right to bear arms for self-defense. The Bruin test, derived from the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, has introduced a transformative standard demanding that arm regulations have a deep historical root or be analogous to historical rules to be considered constitutional. This places a significant burden on the state to justify the constitutionality of its existing arm laws under the Bruin framework. Adam Winkler, a UCLA law professor specializing in Second Amendment law, notes that the ruling exemplifies the growing difficulty for legislators to defend armed safety laws. The evolving legal landscape, particularly post-Bruin, signals a trend wherein the scrutiny on armed laws is becoming more stringent, making it increasingly challenging for lawmakers to uphold or enact regulations without meeting the historical standards set by the Bruin test.
ATF, alcohol, tobacco, and firearms.
Under any administration, would become an ally. It needs to go. We need to abolish.
In Western Colorado, we call that a fun weekend.
The impulsive leaders at ATF have once again failed to apply simple logic and reason to their decision-making.
And now the ATF, under the guidance of this administration, is coming to take away
And every conservative in this Congress to stand with Representative Clyde and his legislation and to stand with me.
Individuals who own pistol braces, which were originally approved by the ATF themselves.
Amy L. Bellantoni, the attorney representing Baird and Gallardo, asserts that California's open carry bans lack a basis in history and should be overturned. She contends that these regulations are inconsistent with the plain text of the Second Amendment, advocating for a preliminary injunction. Van Dyke's urging for the lower court to swiftly reconsider and rule on the injunction request acknowledges the protracted nature of the underlying litigation, which has spanned over 4 years. While the ruling does not set a specific deadline, it emphasizes the need for expeditious resolution. The potential for an appeal loom, and the case's trajectory is contingent on further proceeding in the lower court. As the legal battle continues, the ruling amplifies the ongoing debate on armed rights and regulations, emphasizing the intricate balance between historical roots, individual rights, and contemporary considerations within the framework of the Second Amendment. Arms Law Challenge. A recent decision by the 9th U.S. Circuit Court of Appeals has reinstated a judge's ruling that prevents California from enforcing a new law that restricts the carrying of arms in most public places. The legal battle centers on a law that armed rights advocates argue violates citizens' Second Amendment rights to keep and bear arms. Initially, a 9th Circuit panel had issued a temporary stay on an injunction that blocked the law, allowing it to take effect on January 1. However, a different panel of judges from the same circuit has now set aside the order that suspended the injunction, reverting to the initial ruling that deemed the law unconstitutional. Armed rights groups, relieved by the latest decision, had sought a reconsideration from the 9th Circuit after the temporary stay was issued. C.D. Mitchell, a lawyer representing these groups, declared that the attempt to circumvent the Second Amendment had been halted, at least temporarily. California's appeal of the injunction is scheduled to be heard in April.
Where you guys worked with the ATF to change something that had been the law for 10 years to go after law-abiding Second Amendment.
3-round burst or semi-automatic. Those firearms are not allowed for purchase in the United States today.
The state's attorney general in legal filings argued that blocking the law would increase the risk of armed violence for tens of millions of Californians. The law in question, signed by Governor Gavin Newsom in September, faced strong opposition from armed rights advocates who viewed it as an infringement on constitutional rights. The legal battle underscores the ongoing tension between armed control measures and individual' Second Amendment rights. The 9th Circuit's decision adds complexity to the broader national debate on armed control. While the court's ruling prevents the immediate enforcement of the law in California, the upcoming hearing in April will be crucial in determining the law's fate and its implication for arm regulations in the state. The issue also highlights the political and legal maneuvering around arm laws, with both proponents and opponents framing the debate in terms of public safety. California's Attorney General contends that blocking the law endangers the lives of state residents, emphasizing the potential risks associated with increased access to firearms. Arm rights advocates argue that such laws infringe upon individual liberties, and the recent decision by the Ninth Circuit is seen as a temporary victory in their fight against what they perceive as unconstitutional restrictions.
We submitted formal petitions for rulemaking through the appropriate channels, sir.
We've already lost more than 13,000 Americans to gun deaths so far this year.
The legal saga in California exemplifies the broader challenges faced by policymakers and courts in finding a balance between public safety concerns and individual rights. As the debate continues, the outcome of California's appeal in April will not only influence the state's arm laws, but could also set precedents with implications for the broader national discourse on arm control measures and constitutional rights. Arm rights evolution. The context of the recent legal developments in California regarding arm laws traces back to a pivotal moment in June 2022. At that time, the U.S. Supreme Court, with a conservative majority, rendered a landmark decision in the case of New York State Rifle and Pistol Association versus Bruin. This ruling marked a significant expansion of armed rights across the nation. In the Bruin case, the Supreme Court not only struck down New York's stringent arm permit laws, but also established a groundbreaking precedent. For the first time, the court explicitly stated that the right to keep and bear arms under the Second Amendment extends to an individual's right to carry a hand arm in public for self-defense. It asserted that such laws must be consistent with the nation's historical tradition of arm regulation. This criterion became a benchmark for assessing the validity of arm regulations, introducing a historical perspective that emphasizes alignment with long-standing traditions. The Bruin ruling triggered a wave of legal and legislative actions as states grappled with aligning their arm laws with the new constitutional standard articulated by the Supreme Court. In this context, California enacted a new law that sought to regulate the carrying of arms in public places. However, the recent legal tussle in the Ninth U.S. Circuit Court of Appeals indicates the challenges and complexities arising from the intersection of constitutional rights and evolving legal standards. The ongoing legal battle in California reflects the broader national discourse on arms heart of these legal deliberations.
They want to make it impossible to exercise Second Amendment rights, and what better way to do this than to make it difficult?
By some counts, so far this year, there have already been 174 mass shootings.
As California moved to revamp its firearms regulations in response to the Bruin decision, the state found itself at the forefront of a legal and ideological struggle. The recent decisions and counter-decisions by the Ninth Circuit panels illustrate the complexity of interpreting and implementing the new constitutional standards set by the Supreme Court. The evolving landscape of armed rights in the aftermath of the Bruin ruling has far-reaching implications. The legal developments in California underscore the challenges faced by states in navigating the delicate balance between protecting individual liberties and addressing concerns related to public safety. Ultimately, the legal trajectory of arm regulations, as exemplified by the California case, will shape the contours of Second Amendment jurisprudence across the nation. The interplay between historical traditions, constitutional interpretations, and contemporary realities continues to define the ongoing debate on armed rights and responsibilities in the United States. Concealed carry constitutionality. California's Senate Bill 2, a new law aimed at regulating the carrying of concealed arms, faced legal scrutiny resulting in a U.S. District Judge's ruling on December 20. The law prohibited the carrying of concealed arms in 26 designated sensitive places, encompassing locations such as hospitals, playgrounds, stadiums, zoos, and places of worship. This restriction applied irrespective of whether individuals held permits to carry concealed weapons. The ruling emphasized the unconstitutionality of Senate Bill 2, asserting that it violated the rights of permit holders and armed advocacy groups. Judge Carney's decision, grounded in constitutional principles, reflects a legal interpretation that weighs the Second Amendment rights of individuals against the state's attempt to regulate concealed carry in specific locations.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
President Biden and Steve Diedelbach know that all-out gun confiscation is unfeasible, nearly impossible.
The contentious elements of Senate Bill 2 lay in its broad restrictions on carrying concealed arms in various public and private settings. By designating certain places as sensitive, the law aimed to limit the presence of concealed firearms, asserting public safety considerations. However, the legal challenge contended that these restrictions infringe upon the constitutional rights of permit holders. The ruling not only struck down the specific provisions related to sensitive places, but also emphasized the need for clear signage at privately owned commercial establishments regarding their armed policies. This aspect introduces a balance between the rights of individuals with concealed carry permits and the property rights of business operators. While the legal decision provides relief for permit holders and armed advocacy groups, the broader implications revolve around the ongoing discourse on armed rights and regulations. The intersection of constitutional rights, public safety concerns, and private property rights remains a complex terrain for legislators, judges, and advocates. The case highlights the challenges faced by states in crafting and implementing armed regulations that align with constitutional standards. The tension between ensuring public safety and respecting individual rights continues to shape legal battles and legislative debates in the realm of armed control.
Under the new rule, these firearm owners will be required to obtain special registration
in the United States, and that is not what the Democrats are attempting to ban today, because that's already banned.
As legal battle unfolds, decisions such as the one on Senate Bill 2 contribute to the evolving jurisprudence surrounding the Second Amendment. The delicate balance between individual freedoms and societal interests remains at the forefront of these discussions, emphasizing the need for nuanced approaches to crafting and evaluating armed laws. Public safety and Second Amendment. The tension between public safety and the Second Amendment right to bear arms has been a long-standing and contentious issue in the United States. This delicate balance is at the heart of many debates, legal battles, and policy decisions as the nation seeks to navigate the protection of individual rights while ensuring the safety of the broader community. On one hand, advocates for strong armed rights argue that the Second Amendment guarantees individuals the right to own and carry firearms for self-defense and other lawful purposes. They emphasize the historical context of the amendment, asserting that an armed citizenry serves as a check against government tyranny and protects individuals from harm. On the other hand, concerns about public safety have prompted calls for stricter armed control measures. The proliferation of firearms has been linked to increased rates of armed violence, mass shootings, and accidents. Advocates for armed control argue that reasonable restrictions on arm ownership, such as background checks and limitations on certain types of weapons, are necessary to prevent harm to individuals and society as a whole.
Did you or anyone in your organization communicate with the ATF?
Weaponized against FFLs and the gun industry as a whole as a way of shutting down otherwise legally compliant FFLs.
The Ninth Circuit's response, characterized by defiance and delays in the implementation of certain laws regulating concealed carry, reflects the challenges of reconciling constitutional rights with concerns about public safety. The Circuit's decisions, influenced by the evolving legal standards set by the Supreme Court, contribute to the complexity of the issue. As the legal landscape unfolds, it is crucial to consider the nuanced perspectives within this debate. Striking an appropriate balance between protecting the Second Amendment and ensuring public safety necessitates thoughtful and informed policy making. It involves addressing issues such as background checks, mental health assessments, and restrictions on certain types of firearms to mitigate potential risks. The ongoing dialogue and legal battles underscore the need for comprehensive approaches that consider both individual liberties and the collective well-being of the community. In this intricate interplay between constitutional rights and public safety imperatives, finding common ground becomes a challenging yet essential endeavor for policymakers, lawmakers, and the judiciary. That's all for this video, folks. See you next time.